Well, hello, everyone. This is Adriana Michaels, real estate advisor with Engel and Volkers, LA South Bay. So today I'm going to be covering an important topic on homeowner essentials and estate planning, and I'm so excited to have a very special guest with me today. His name is Cedric Collins, and he's the founder of Legacy One Law Firm. Welcome, Cedric.
Thank you so much for that warm introduction, Adriana. It's a pleasure to be here this afternoon.
You're very welcome. I'm so excited to have you here. Cedric, can you tell me a little bit more about yourself and your firm?
Absolutely. I'm the founding attorney at Legacy One Law Firm. We're a small boutique law firm located here in Southern California. However, we serve clients all over the great state. And the thing that makes us a little bit different is we have a relationship-based style of estate planning. And our primary goal is to work with individuals, businesses, and families to help keep their families out of court and out of conflict in the event of death or incapacity.
Wonderful, wonderful. Since our topic today is homeowner essentials and estate planning, how do we even start with estate planning?
Well, Adriana, that's a very good question. First of all, I'd like to start off by saying that, it's difficult sometimes for us to discuss our own death or our own mortality, right? The fact that we're all going to leave here one day. And the first step is to just have that conversation with yourself. What would happen to my loved ones? What would happen to my kids? The things that I've worked hard for if something were to happen to me? Not just at death, because you may survive an encounter, but just be incapacitated and unable to handle your affairs. So it's very important to have that conversation, first of all, internally with yourself, that internal dialogue. If you are married, have a significant other, begin having that conversation with that person or that individual and your family members. And then once you've had that conversation, the very next step is to memorialize it, right? To put it all in writing. And that's where we come into play.
Got it. So start with the conversation.
Absolutely.
So what are the benefits of estate planning?
Well, there's so many of them. So here's the thing, we live in California, and there's a lot of people that live in California. Therefore, there's a lot of people that actually die here in California. And so once people start hearing about this process called probate, right? One of the number one reasons our phone rings, which is a litigation. Probate is a litigation that's opened up against the estate of the person who's died. First of all, for the benefit of the creditors, and secondarily for the benefit of the heirs or beneficiaries that are left behind. And probate is something that is often misunderstood. But what I can tell you is this: it's a very time-intensive, time-consuming process. It adds on additional stress to the ones that you leave behind, and it's quite expensive. So the primary benefit of having the right type of estate planning in place is you can avoid the probate cost and the effects of probate. Well, another benefit is just having the peace of mind that your final affairs are going to be in order. We all have family members that we know that may not be that agreeable. Some of us have. And so it could turn out to that there may be fighting or discord amongst siblings, amongst kids, grandparents and parents over your assets. So having an established or written down estate plan that can be followed, because your estate plan is going to be instructions and your wishes for what you want to occur with the things that you've worked hard for. And so by having that in writing, it's going to reduce the amount of conflict. So not only is there a time savings, a cost savings, but a significant reduction in conflicts by having your wishes spelled out in writing.
Got it. So if you don't have a plan in place in writing and you pass away, what happens?
Well, I like to say this: if you don't have a plan, the state of California has a plan for you, but you might not necessarily like what it is. And one of the things that we want to talk about here is what happens if someone dies without, let's say, even a basic will. Under the law, that's called intestacy. Your died intestate means you died without even a will. So what happens there is now there are laws in your state that they're kind of like default rules. This is what happens. So since you don't have a plan, our default plan kicks in. And now the court has to decide through the guidance of the law, how your assets are divided up. If you have children, the court will even decide what happens to your kids. So not having a plan in place really just leaves a lot of things up to chance. If you don't have a plan in place, just know that the things that you've worked hard for might not end up in the hands that which you want them to end up in. They may end up in different hands, different family members. So it's so critical to make sure your wishes are expressed and made known, or the default rules are going to apply.
Sure. And some of the questions that I get from homeowners all the time is, what's the difference between a will and a trust, and what's better, with the homeownership?
Well, with regard to the differences, there are several differences between the will and the trust. Now, wills are the traditional means of planning, right? We've all heard the stories about something going wrong with a will, or a will that's being contested, but there's often times where a will just may not be enough, right? So one of the primary differences that between a will and a trust is that a will speaks only at death. So once you pass on and you have a will that's executed, it goes to the probate process. And the probate process actually comes from a Latin word called proving. That's where they're actually going to prove the validity of your will, right? So the wills go through probate. Conversely, with a trust is a private instrument that's executed in private, and your wishes are carried out outside of court involvement. So court involvement is a big difference. Will, you're going to expect to go to court. With a trust, you're going to seek to avoid that court process. And also, when I have to touch back on speaking at death, the will is only valid at death. However, your trust, if you have a living trust, it can account for your incapacity as well. In certain events that you might not pass on, you can have a trustee that can step in and manage some of your affairs. So those are the two primary differences. But one difference that's also often overlooked is the flexibility that a trust provides that a will may not be able to provide. See, the court has limited time and limited resources to wrap up your affairs. Hypothetically, if you have a child who's, let's say, 15 years old, and you want to leave them a piece of real estate, well, if you try to pass that down through a will, the court's going to want to make sure that property is taken out of its jurisdiction as quickly as possible. However, with a trust, it can account for the fact that your child is only 15 years old, and that asset can be held in trust and passed down to that child at a future date, which you determine. That's just one example of the type of flexibility that you can have through planning with a trust versus a will, which is not as flexible. You don't have as many options when you're planning with a will. So those are just some of the primary basics and differences between the will and the trust. Also, something to point out, the trust is a contract, which is an agreement between a trustee or trustor who's basically passing down to the trustee to take responsibility of assets that are going to be passed down to beneficiaries who you've named in the trust instrument. Whereas the will is basically more of a testamentary instrument meant to devise of your estate and assets through the court process. That makes sense. So those are some of the differences. I know I said a lot there, but those are the general differences between a will and a living trust.
So it makes much more sense as a homeowner to have a living trust.
Well, it may. And so a trust may not be for everyone, but here, if you're a homeowner, let's talk about this for a minute, because most of your audience, they're homeowners are in the process of perhaps seeking to purchase a home. Correct. Now, if you have a home here in California, we know how expensive the home prices are here. It can be $500,000, $700,000, even $1 million. For many people, their home is their most significant asset. And so not having a living trust, maybe planning with just a will or having no plan at all, means that your house, if you put it in that will or don't have a plan at all, can be tied up in the court systems for anywhere from 6 to 24 months. So that's a long time to have that asset tied up, not to mention the time that someone's going to have to take off work to make sure that this asset is passed down to the next generation. So you can save your family a lot of stress and a lot of financial costs by making provisions in a trust to have your house passed down to the next generation.
That makes so much sense, and it sounds so much easier.
Absolutely. We want to do this as quickly and as efficiently as we can for clients. So a trust, I say 80% of my clients here at the firm who estate plan, it's no coincidence, they are homeowners. And I say 99% of them, they do plan with a living trust.
Makes sense. Now, if you do have a trust in place or a will and you pass away, and you have adult children or whoever it passes on to, will there be paperwork involved for those left behind?
Well, there's always some type of paperwork that someone's going to have to do. You have seen things such as final expenses. Maybe there's final healthcare cost if someone's passed and they left medical bills. Maybe there's the final funeral expenses. So there are a number of things that are going to have to be wrapped up and taken care of. The difference here is the court going to take care of this, which they're going to charge you a pretty penny to do, or is this going to be handled privately by someone you trust? And we'll help you have that conversation and lay out the differences between having a court process involved with your final affairs and having something done privately.
Makes sense. So now there's also, can you tell me a little bit about the different directives, and should you have directives in place? That comes hand in hand.
Yeah, it does. And we call these the essential documents. Here at Legacy One, we focus on comprehensive estate planning. We want to make sure our clients are taken care of from A to Z, not just when they die, but what if they don't die? They survive. Someone's in a car accident and they say two spouses hypothetically are in a car accident and both of them are on life support for maybe a couple months or several weeks. Who's going to step in to make those, first of all, critical healthcare decisions? So the first essential document is the California Advanced Healthcare Directive. This is the document that states if you or your significant other, or if you're single, if you are incapacitated, who will step in to make those critical healthcare decisions? Are we going to leave these decisions up to the hands of the medical professionals? Or are there certain certain methods or ways that you would like to be cared for, that you'd like to have memorialized in writing and appoint someone who you trust to ensure those wishes are carried out? The second essential document is the durable financial power of attorney. The same couple is in a hospital bed. They're incapacitated. Well, who's going to step in and pay their mortgage, right? We're talking to homeowners here. Many of us have mortgages, right? Well, who's going to continue to make that mortgage payment if you cannot? Also, who's going to help protect your good credit? You have to have pretty good credit to own a home, right? So you worked hard to build that credit. So now, why are we going to leave that to the chance of being jeopardized because now we're incapacitated? And now what happens if you don't have those documents in place? We have to seek court intervention, which is additional time and financial resources that we may not want or we may not be prepared for. A couple other documents that we consider essential: if you have kids, naming legal guardians for your kids is so important. Who else is better positioned to determine who will step in your shoes than you are?
Exactly.
The court does not know the subtle nuances and the tendencies of a family member that you don't get along with. But that same family member, if you have an appointed guardian, something happens to you, they can petition to take custody of your kids. And so we believe, we have most clients agree with us, that the client, the person, the parent, is in the best position to determine who will step in their shoes. So naming legal guardians is so critical, so important. And finally, we call these final disposition instructions. Do you want to be buried? Do you want to be cremated? Well, let's get that in writing as well. So these are what we call the essential documents that should be included in every comprehensive estate plan. And the planning that we do for families, we make sure that we include these essential documents.
Sure, very important and very critical for every family. It's something we don't think about on a daily basis. So starting that conversation, I guess, would be the first thing to do.
Absolutely.
Right. And Cedric, can our viewers learn a little bit more about Legacy One Law Firm and how they can get started with this type of planning? I think that would be wonderful for them.
Absolutely. So they can learn more about how we serve families, first of all, at www.legacyoneLaw. That's the word legacy. We spell out ONE law.com. There we have a number of blog articles and resources, free resources that you can just kind of learn about what the process, is in general. You can also reach out to me directly at scollins@legacyoneLaw.com. We'll also have our contact information on the screen here as well, 323-405-7017. That's our direct line. You're more than welcome to reach out to us to schedule a time where we can meet with you, your significant other, if you're married, and let's just get that conversation started, and we'll be more than happy to share with you all the details with regard to this type of important planning.
Thank you so much, Cedric. This information was so important, to our viewers, to me, for everybody. And I really, really appreciate you being here today. Thank you so much.
You're quite welcome, Adriana. It's really a pleasure. And thank you so much.
Yeah, no, great. Thank you. And to our viewers, this is Adriana Michaels with Engel & Volkers, LA South Bay. If anyone has any real estate questions or needs, you can contact me. My phone number is 310-658-4590. And the market right now is extremely hot. The rates are great. So, it's a great time to sell or to even buy. Okay, so thank you for joining us today and hope to see you soon.
Bye-bye.
Bye-bye.